Welcome everyone. We're going to get started in just a minute. Welcome to our friends and colleagues who are here live, as well as the 50-odd people who are so far on Zoom. But we have a big audience, which is great to hear this wonderful lecture. Lovely. So welcome, everybody. My name is Anita Allen. I'm the Henry R. Silverman Professor of Law and Professor of Philosophy here at Penn. And to begin our program, I would like to ask you that you please silence your cell phones. Silence your phones. On behalf of the Center for Africana Studies, welcome to the 2022 Honorable A. Leon Higginbotham Jr. Memorial Lecture. This annual lecture honors the legacy of Judge Higginbotham and is co-sponsored by the Center for Africana Studies and the Law School. We're delighted this year to have a colleague and friend, Dean Linda Sheryl Greene, as our speaker for the Higginbotham Lecture. At this time, it's my privilege to introduce our Dean, Ted Ruger, Dean and Bernard G. Siegel Professor of Law here at Penn, who presents some welcoming remarks. Ted is, as most of you know, not only a phenomenal constitutional law and health law scholar, but a transformational dean of our law school. Ted?
Thank you, Anita, and I'm about to hand it back to Professor Allen, who serves not only to welcome from our valued partner here, and I also want to thank the Center for Africana Studies, but also a leading member of the law faculty, and so Professor Allen will help better introduce this lecture and the role that Judge Higginbotham played here at the law school, at this university, in this city, and in this country, and really world-renowned for his pioneering jurisprudence and commitment to civil rights and justice. I have really been grateful to work with and benefit from the insights of the leadership of our colleagues at Africana Studies every year. This is an annual event, the Higginbotham Lecture, and we've had an amazing set of speakers coming through both before the pandemic, virtually during the pandemic, and then happily this year welcoming Dean Linda Greene in person. So welcome, Dean.
Thank you.
One constant has been honoring the really remarkable commitments the judge has made to this institution and to the broader world. It was the photo behind me, just as sort of another wonderful thing in the life of this city, and building on thousands of other murals that have been done by the Philadelphia Mural Arts Project and in partnership with the Philadelphia Citizen. We were happy to celebrate, and those of you who are driving toward Penn, eastbound on Chestnut Street between 46th and 45th in the future, we'll see this mural behind me honoring the judge. And so it's the next special significance, and I think both in person here and among the online group, there are people who may be members of the community who we welcome you to our halls virtually or in person and hope you come to future lectures. This is an annual event. I will hand it back to my colleague soon, but just the one slice of the judge's remarkable influence I would emphasize, since we are in an academic setting, is he was a terrific and incredibly impactful teacher here at the University of Pennsylvania Law School. So among all else that he did nationally and on the bench and fighting for civil rights through his opinions and his writings and his work, he had that kind of exponential quality that the best teachers have, and I'll hand it back to one in Anita Allen and another one in Linda Greene in a minute, but that not just teaching and leading by his own example, but then there are judges and lawyers and professors today, some of you in the audience in person or virtually, who were inspired by the judge. Many of them told me that the most important professor they had, and this is at the same time he's working on the Third Circuit and writing impactful opinions, but to be able to teach here, that's a legacy he has that still reverberates in the work that his former students do. So we're very happy to and grateful to honor the judge and have other eminent legal educators help us do so. And so with gratitude, turning it back to Professor Allen and Dean Greene, thank you, and I look forward to your remarks.
Okay.
Oh, I neglected to do one thing. Some of you are watching or sitting in the room taking this for CLE credit. And the way CLA works, there's going to be 3 words that sort of prove you were listening. And the first word is unity. Unity, yes.
Perfect, perfect. The community began to assemble and honor, in unity, honor the legacy of Judge Higginbotham, even before he passed on. So the first lecture was in 1989. After his death in 1999, the lecture series was renamed the Honorable A. Leon Higginbotham Memorial Lecture. And this happens every fall now. And the topic can be any event or personality or issue that affects the African American community of either historical or contemporary significance in the areas of history, law, sociology, or social justice. And with those themes in mind, we've had an array of amazing speakers come to perform the Higginbotham Lecture over time. Past lectures have included Patricia Williams of Columbia University, Charles Ogletree of Harvard Law School, Dean Derek Bell, because he's sort of the dean of critical race theory, I guess, right? So Derek Bell, Harvard NYU Law Schools, Nigerian human rights lawyer Hawa Ibrahim, Haitian human rights lawyer Mario Joseph, the famous Brian Stevenson, executive director of the Equal Justice Initiative, University of Pennsylvania's own Mary Frances Berry, Evelyn Brooks Higginbotham, professor of history and Africana studies at Harvard, Kahil Gibran Muhammad, director of the Schomburg Center in New York, Sheryl Eiffel, president and director counsel of the NAACP Legal Defense Education Fund, and recently Dr. Eddie Glaub Jr., the James McDonald Distinguished University Professor and Chair of Africana Studies at Princeton. And our speaker tonight falls right into that group as an outstanding figure in the legal and academic communities. We try every year to remind our audiences of the tremendous legacy of A.L. Higginbotham Jr. And I'm going to tell you a little bit about him. It's a little bit, but it's also a lot, just to give you a sense of this amazing person. He accomplished so much. You know, we all talk about how do we manage our time, how do we manage to do so many things. Here's a person who in his lifetime led 4 lifetimes. So Higginbotham was born in 1928 in Ewing, New Jersey. He got his bachelor's from Antioch College. He got his LLB with honors from Yale Law School in 1952. He began his legal career as a law clerk for Justice Curtis Bach on the Philadelphia Court of Common Pleas. And in 1953, he was appointed assistant district attorney in Philadelphia. In 1954, he became a founding partner of the very first African-American law firm in Philadelphia, Norris, Schmidt, Greene, Harris, and Higginbotham. So while he was in private practice, he also performed numerous public functions and capacities, including Special Deputy Attorney General for the Commonwealth of Pennsylvania, Special Hearing Officer for Conscientious Objectors in the U.S. Department of Justice. He served as Commissioner of the Pennsylvania Human Rights Commission. He served as President of the Philadelphia chapter of the NAACP, and he was a board member for various legal, political, and nonprofit organizations throughout Pennsylvania. In 1962, President Kennedy appointed Higginbotham to the Federal Trade Commission, making him the youngest person to serve on a federal regulatory commission. In 1963, President Kennedy nominated Higginbotham for the Eastern District Court of Pennsylvania, but the nomination lapsed due to Southern politics in the Senate. Sound familiar? In 1964, Higginbotham received a recess appointment, though, from President Lyndon Johnson and was confirmed in March, making him one of the youngest judges ever appointed to the federal bench. Higginbotham played a really remarkable role in the civil rights movement as he was asked to advise President Johnson after the assassination of Dr. Martin Luther King. He served on the National Commission on the Causes and Prevention of Violence under Johnson. And in 1967, President Carter appointed him to the United States Court of Appeals for the Third Circuit, where he remained for 16 years, serving as chief judge from 1989 until 1991, and as senior judge until his retirement in 1993. Already several lives lived. Upon retirement from the Court of Appeals, Higginbotham became the public service jurisprudence professor at Harvard University's Kennedy School of Government. He also served as an international mediator during South Africa's 1994 elections and as counsel for the Congressional Black Caucus in a series of voting rights cases before the United States Supreme Court. In 1995, President Clinton appointed him Commissioner of the United States Commission on Civil Rights, and he was also counsel to the law firm of Paul Weiss, Rifkin, Wharton, and Garrison. We haven't even talked yet about his life as a scholar. As a historian, Higginbotham contributed to more than 100 publications and academic works and produced several critically acclaimed works, including the book In the Matter of Color, The Colonial Period, 1978, and Shades of Freedom, Racial Politics and Presumptions in the American Legal Process. And I must tell you that I'm not one to weep reading books, but at the end of In the Matter of Color, I found tears streaming down my face. So beautiful was his rendition of the early days of enslavement and its implications for America. During his lifetime, Judge Higginbotham received several national and international awards and honorary degrees from more than 60 universities. Citing his commitment to equality and civil rights, President Clinton awarded Higginbotham the Presidential Medal of Freedom, the nation's highest civilian award. That was in 1995. During his more than 30-year relationship with the University of Pennsylvania, as Dean Ruger intimated, Judge Higginbotham was a member of the Board of Overseers of the Law School. He was chairman of the Board of Overseers of the Law School and the Graduate School of Education. He was an adjunct professor in the law school, and he was a university trustee from 1968 till 1998. In recognition of and appreciation for his, quote, generous service to others, his judicious compassion, and his warm understanding of man's thoughts and foibles and strengths, Penn's Board of Trustees conferred upon Higginbotham an honorary degree, Doctor of Laws, in May of 1995. That is our remarkable judge, the person for whom this lecture series is named. I'd now like to say a little bit about our speaker this evening, Dean Linda Sheryl Greene, who is the Dean of the University of Michigan State Law School. Linda, I've known since I was a baby law professor, and she was also a baby law professor, semi-baby law professor. But what I remember most about her is that she was one of the principal organizers of the first Critical Legal Studies Conference meeting that was held in Wisconsin back in the early 1995 era. 95-ish, maybe 92-ish, early 1990s. But she was in the room where it happened. She was in the room where civil rights law happened and where critical race theory happened. So basically, let me give you some background. So Linda is a graduate of Berkeley Law School. She was a civil rights and constitutional law attorney at the NAACP Legal Defense Fund. She was also Los Angeles Deputy City Attorney who specialized in civil rights and constitutional law, and she was counsel to the U.S. Senate Judiciary Committee. She was chair in 1990 of the Wisconsin Conference on Critical Race Theory. That's the one I was thinking about, 1990. And she was also president of SALT, the Society of American Law Teachers, and a founder, if not the founder, of the People of Color Legal Scholarship Conference movement, vice chair of the council and council of the Legal Educational Opportunity Organization. She co-founded Black Women in Sports Foundation and served on the U.S. Olympic Committee as chair of its legislation committee and the vice chair of its audit committee, and was a member of the University of Wisconsin-Madison Athletic Board. And I asked her today, where did the sports thing come from? And it turns out that she ran track in high school and has been a sports junkie ever since. From 2013 to 2019, she was member of the National Institutes of Health National Advisory Committee on Minority Health and Health Disparities. Her recent scholarship reflects the breadth of her experience and interests. I'll just briefly read some of the titles of her articles and other materials. The Battle for Brown versus Board, African American Women on the World Stage, A Tale of Two Justices, Brandeis, Marshall, and the Federal Court Diversity, Talking About Black Lives Matter and Me Too, Up Against the Wall, the Congressional Retention of the Spending Power in Times of Emergency, and Critical Race Theory, Origins, Permutations, and Current Queries. Her recent works are really a reflection of not just the breadth of her interests, but in her continuing commitment to keep abreast of contemporary issues and to bring her wisdom and insight to those important issues. She's lectured on constitutional law and advised governments around the world, including trips to Austria, France, Germany, Japan, Mozambique, Norway, South Africa, Thailand, Zimbabwe. Last March, she was a Fulbright specialist who lectured and advised on the new Chilean constitution. She's been a media personality on Wisconsin Public Radio and Television, National Public Radio, and she also has written for the New York Times many op-ed pieces throughout her career. So we look forward this evening, Dean Greene, to your lecture remarks on the topic of the desegregation of higher education, past, present, and future.
Thank you.
Thank you.
Thank you. Thank you. Oops. Oh. Don't lose the mic. Don't want to lose the mic. Not sure. There we go. I am so honored to have the opportunity to speak to you today. But before I begin, I want to acknowledge the Honorable Leon Higginbotham, for whom this lecture is named. You had incomplete discussion of his many accomplishments. He was a guiding force for so many here in Philadelphia, in this country, and in the world. I was a young professor at Temple University, and shortly after I arrived in town, as a properly raised young person, I paid a courtesy call on the judge and also on Judge Greene. That was rewarded many times with fantastic conversations and musings of the judge. And those of you who knew him well knew he loved to muse on all sorts of things and problems and challenges. He was a delightful conversationalist and so generous, especially to younger people. And so I was one of those younger people, and I do try to follow his example of generosity to others, which was very, very special. He was a judge, but he was fundamentally an intellectual and a professor at heart. He talked about his book, In the Matter of Color, just out. I decided to bring 30 of my students to visit Judge Higginbotham in his chambers, which was absolutely thrilling for them. And he talked about his book, he talked about his next research project, and he also gave profound advice to them about the meaning of the opportunity to study law and about how hard fought and hard won that opportunity was for, especially for Blacks, but for really all diverse people. He died much too young, but he left behind a different world for us, a world in which we imagined our opportunity, no, our obligation to make a difference in the world, to weave the words on the frieze of the Supreme Court, equal justice under law, into the fabric of American life. And let me just go to my little thank you slide to remind me. I have a few thank yous. First, to the amazing Silverman professor and winner of the Quinn Prize in Philosophy, Anita Allen, who conspired to initiate this opportunity. To Professor Camille Charles for her formal introduction. Camille, I didn't see you yet. Back there. Great. For this introduction. To Tia Campbell, who is the master of all things logistical and detailed. To my invaluable executive assistant, Tammy DuPont, who amazingly cleared my schedule so that I could be here, and my fellow dean can understand how miraculous that could be. To Timothy Ennis, our research librarian, and to Anne Marie Guattari, my communications director, with whom I worked on the design and structure of this presentation. And of course to Judge Leon Higginbotham for his courage and for his inspiration. As I reflect on our country's history, with regard to education and race, I ask myself, are we on the brink of another day of racial reckoning? We have had so many in our past and also in our present. Here is my short list of days of racial reckoning. There are many more, of course, but when I think about what might be characterized as a day of racial reckoning, I fasten on decisions that have changed the course of our history, changed our understanding of the role of institutions and the judiciary in what I call the ongoing We the People project, that unfinished project. I also think about the cases that have provoked fundamental debates over the meaning of citizenship and inclusion in the 20th and 21st century. And I just offer these as examples. They're on my short list. For example, civil rights cases in 1883 erased the right of blacks to federal protection against private discrimination, a defect that was not remedied until after the mid-20th century with the passage of a Federal Civil Rights Public Accommodations Act. Plessy confirmed the constitutionality of a system of racial apartheid, including in education, that continues to define the American racial experience. Brown won, the product of a 25-year campaign by Charles Houston, William Hastie, and Thurgood Marshall, fixed our formal break with Plessy's equal but separate framework and allowed us to resume the work of an 11-year reconstruction between 1865 and the end of the Civil War and the Compromise of 1876 that ended Reconstruction. 68 years later, we celebrate that victory and the consequences, and we continue to debate whether it is enough to take down the white and colored signs. In Heart of Atlanta versus Motel, the court sustained a 1964 federal public accommodations law enacted after courageous students sat in to start a movement that ended with the March on Washington and the 1964 Civil Rights Act. It had been 81 years since the Supreme Court struck down the post-Civil War public accommodations legislation. And then Rodriguez versus San Antonio. We don't always put this case in that category, but in this case, and I will say later, at a time when the Supreme Court had not very recently clarified the obligations of school districts to desegregate, Rodriguez decided that there was no right to education, and that the arrangements that fundamentally condemn largely Mexican-American children to marginally resourced schools were the sole responsibility of states and local government. And as a result, the entire project of equal education would turn on the contested meaning and fraught trajectory of an equal protection clause rather than a fundamental right. So these cases are just a few forks in the road of our constitutional racial subordination journey. The opportunity of our court to sustain or impede or further constitutional full citizenship is what we ask about today. Are we headed for another day of racial reckoning? Consider the two affirmative action cases that are currently before the Supreme Court, the Students for Fair Admissions versus President and Fellows of Harvard College, Students for Fair Admissions, and the University of North Carolina. The Supreme Court had oral arguments on both cases, and the question is whether the Supreme Court should hold whether institutions of higher education cannot use race as a factor in admissions. If the court decides no, that means overturning the 2003 case in Grutter versus Bollinger, which decided that higher education institutions could use race as a factor in their admissions decisions. So what is at stake in these affirmative action cases? Yes, to be sure, we are talking about just two institutions, but they are institutions that are not only important in our society, they're also institutions that are representative of many that would like to provide more educational opportunity to racial minorities. It's important to understand how these cases fit into the meaning of equal protection. So how do they fit? How important are they to the desegregation of higher education? Certainly, the press attention and clamor have to do with the fact that they are race cases, and those are always of interest, not only to law professors and law students and judges, but to the general population. And in order to decide whether the vote to forbid the use of race in admissions in higher education is significant, it would be useful to understand something about our historical backstory against which these cases are decided. And that's a 400-year backstory. It's also important for us to examine the relationship between race and education in America's backstory. Do these cases represent just one of the numerous options for the desegregation of higher education and the advent of racially inclusive higher education institutions? Or do these cases represent the last slender thread on which the higher education desegregation project hangs? Some constitutional history may be helpful. Many of us know this story, but it's important to situate our discussion today about opportunity in higher education against a background of over 400 years of racial apartheid. We have, at 1619, a ship carrying more than 20 enslaved Africans arrived in the English colony of Virginia. The official Juneteenth flag represents a star representing Texas, the Lone Star State. We also have what some have called a slave constitution. A slave constitution. What does it mean when we say we have a slave constitution? Well, it's true that since 1789, we are the longest surviving written charter of government. And our three words at the beginning, we the people, affirm that the government of the United States exists to serve its citizens. But how is citizens defined in this original document? Let me just see. Yeah. In this original document, we had three clauses that protected slavery under our Constitution. We had a 3/5 clause that allocated representation in the House of Representatives with a slave counted as 3/5 of a person. We had a delay in a ban on the importation of slaves into the United States until 1908. And we also had a fugitive slave clause that required persons fleeing a state to be delivered to their owners, not mentioned, but to deliver to those to whom they owe service. No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service is due. We also had some decisions in the first half of the 19th century that officially defined the fundamental values of our Constitution. That officially, sorry, it's a sensitive, yes, that defined the fundamental values of our Constitution during this period. In Prigg, a controversy arose over whether Pennsylvania could prosecute a slave catcher who refused to follow Pennsylvania's laws that required that claim be presented to a court. And in the course of that case, the Supreme Court had the occasion to articulate some fundamental values of the American Constitution that should be taken into account in determining whether the Pennsylvania law could be enforced. The court said the Fugitive Slave Clause and the protection of slavery was fundamental to the formation of the Constitution. that states cannot interfere with the unconditional constitutional right of a slaveholder to possess his slaves, and that congressional legislation on the subject of slave return preempts and forbids state laws on the subject. We also see our familiar Dred Scott, who was an enslaved person in Missouri. For a time, he traveled with his master, who was in the Army, to a free state, and when he returned to Missouri, he filed a suit in Missouri court for his freedom, claiming that his residence in the free territory made him a free man. Later, eventually, this case comes to the Supreme Court, and the Supreme Court decides that there is no right of Congress to pass laws that limit the expansion of slavery to the territories, no right to pass those laws, but most importantly, and the most profound language, involves the discussion of citizenship for purposes of diversity jurisdiction. Rather than covering that specific topic, the court answered a bigger question, whether blacks were intended to be citizens of the United States. And on a number of grounds, the court said that neither free blacks nor enslaved blacks were citizens of the United States. We had a civil war. We had an amendment that abolished slavery, an amendment that provided citizenship, overturning Dred Scott, and also set out equal protection of the laws as a framework for the future of equality. Also a 15th Amendment. And during the time after this, during the time between the end of the, So between the end of the Civil War, the passage of the Reconstruction Amendments, and then to 1899, there were developments that suggested that the promise of equality may have been an empty one. One of the most important developments was the decision of the court to strike down the Civil Rights Acts that Congress passed to protect the newly freed slaves from racial discrimination in public accommodations. Another development was a decision, Strader, that held that race-based exclusion of people from juries was unconstitutional, but also listed a number of other neutral, merit-based factors that that states could use in order to exclude people who were not qualified from jury service. We also had the decision in Plessy versus Ferguson that decided that segregation, state-mandated segregation in public transportation was constitutional. And to return to our educational theme, to close out that century, the court decided a case called Cummings versus School Board, in which a school district decided to provide high school education for its white students, but elementary education for its black students. And in the course of that decision, the court not only sketched out the idea that these decisions belong to the local governments to make, but also that there would be deference to any deference in the context of any lawsuit where such a practice were challenged. So then we end then in 1899 with sanctioned school segregation, and there were also other cases that reinforced that as well. As a result, we come to a third part, the first third of the 20th century in a segregated society, in a society where education was either not provided or provided on a limited basis. And that takes us to the really important cases involving education that set the stage for Brown. One of those cases is the Murray versus Pearson case out of Maryland, where Murray sued to attend the University of Maryland because there was no black school in Maryland, no black law school in Maryland. And in that case, the Gaines case was a part of that preparation. In the case of Gaines, Gaines wanted to attend the University of Missouri Law School, which was also white by law. And in the Gaines case, the Supreme Court actually decided that the policy was unconstitutional, but it decided not to order admission, but remanded the case. As a result of the history of the case, the University of Missouri continued to resist integration and didn't admit blacks to its schools until the late 50s. Two more cases, McLaurin and He-Man Sweat versus Painter. In McLaurin, the University of Oklahoma was also segregated. McLaurin applied for admission to study education in the grad school. There was no program of this type in the black universities. Oklahoma denied admission. Justice Marshall brought suit, and the Supreme Court decided that the program was unconstitutional, and therefore admitted him to the University of Oklahoma. There's a lot of interesting discussion in the case, about the conditions under which the Oklahoma admitted McLaurin and whether those conditions were conducive to his enjoyment of an equal education. The Oklahoma legislature changed the law to permit admission of blacks to the University of Oklahoma on a segregated basis. It also assigned him a desk outside the classroom, assigned him a desk in the main reading room of the library on a mezzanine floor, and assigned him a table in the cafeteria. In the course of the court's decision, the court talked about the importance of interaction with colleagues as a fundamental basis for participation in a profession. In Sweat versus Painter, He-Man Sweat applied to the University of Texas Law School, was denied entrance, and later the district court decided that the failure to have a black law school was fatal, but didn't order admission and gave Texas 6 months to create such a law school. The law school was very poorly resourced, very small law school, no library, etc. And the Supreme Court noted that the law school excludes from student body members the racial groups which number 85% of the population of the state and include most of the lawyers, witnesses, jurors, and judges, and other officials with whom the petitioner will inevitably be dealing. And with such a substantial and significant segment of the society excluded, we cannot conclude that the education offered petitioner is substantially equal to that he would receive if he was admitted to the University of Texas Law School. And I want to pause here because here are cases in which the Supreme Court, before Brown versus Board of Education, is outlining the severe deficits that people suffer if they do not have the opportunity to participate in institutions where the leaders of society are present and where they will be educated. And so one of the questions I think that we should ask as we think about the potential consequences of the fair decisions is whether, if the court were to strike down Grutter, is the court turning the clock back to 1950, even turning it further back than Brown. So we know Brown versus Board of Education decided that a separate elementary school system was unconstitutional, and did so on the basis of several factors. One, the court looked at the importance of education in society today, then, in 1954, not its importance in 1868 or in 1865. So that was a very important part of the framing of the decision. In addition, the court looked at the effect of segregation on black children and concluded that that effect was a stigmatic effect. Now, of course, the Brown research has been much criticized, of course, but even so, the court looked at two factors to determine what the outcome might be. The importance of the activity in society and the importance of the activity to the individual, as well. It looked at the importance of the activity to the individual, as well as the effect of exclusion on the individual. And I mention this at this point too, because when we are evaluating what might be the effect of the fair cases should the court decide to overrule Bruder, we have to think about what is the effect of having a society in which many of our important institutions remain virtually racially segregated. What is the effect? We don't usually ask. What is the effect on those who attend such institutions? The Supreme Court didn't discuss that in Brown, the effect of the segregation policies on white children, but what is the effect of the decision to overrule Bruder? What would be the effect of that decision on society as well? So after Brown, just go forward. After Brown, we saw 2 decades of cases that established remedies to limit segregated schools. And there were cases that provided strong statements about those remedies. Now, that didn't occur immediately. Let me just advance. That didn't occur immediately because initially, on the basis of an agreement that the Justice Warren would postpone the discussion of remedies for the violation of equal protection. On the basis of that, the court takes up the question of remedies later, and it decides to offer a menu of possible justifications for delay and close with the now infamous all deliberate speed language. And if there was deliberation, there certainly was little speed. There was shocking pushback in Arkansas and Virginia, in which the governor closed the schools rather than integrate them in Arkansas, and in Virginia, where the school board closed the schools for 4 years, providing grants and other assistance to whites so that they could attend private schools. A survey of school desegregation in the southern and border states completed in 1965 by the United States Civil Rights Commission demonstrated very little progress. In 1965, only 2.5% of black children in the 11 southern and border states under judicial supervision attended integrated schools. 1,500 school districts of 3,000 school districts were still fully segregated. And so the court, there were other factors that moved on the project of desegregation, including the threat that school districts that did not comply with Brown would lose their federal funding. But against this background, the court decided the case of Greene versus New Kent County, where it concluded that freedom of choice plans that did not work were not adequate responses to Brown. The court also talked about the delay in actually the implementation of Brown. The court said that the clock has run out, that the time for mere deliberate speed was over, and that the burden on a school board is to come forward with a plan that promises realistically to work and promises realistically to work now. The next case was Swan versus Charlotte Mecklenburg, which afforded the district courts a broad array of remedial tools to achieve a unitary system, including the use of mathematical ratios, the alteration of attendance zones, and transportation of students, which we, of course, we now call busing. But another important thing about Swan is it elevated to visibility certain tensions that had emerged in equal protection doctrine. What is the nature of racial discrimination prohibited by equal protection? And what are the limits of that clause? What is the contribution of other forms of racial disparities and discrimination to school segregation, such as housing and employment discrimination? And are those factors and contributions measures that the court may take into account in deciding whether there's a violation of the 14th and also in deciding remedies? And do school boards have the obligation to address these other factors in order to provide equal protection of the laws? Another important point Swan raised was the role of private prejudice in the maintenance of racial segregation. What might be the obligation of courts to address that factor? And in Swan, the court suggested that segregation caused by racial prejudice would not be within the power of the court to address. And what about remedial tools? Swan spoke very, very broadly about those tools, but in a series of decisions that ultimately reflected the change in judicial philosophy between the Berger Court and the Rehnquist Court, the court began to sharpen the distinction between de jure and de facto discrimination, eventually holding that remedies could only address the former. Going forward then, the Supreme Court imposed a variety of limitations on the scope of remedies for de jure segregation. For example, in Milliken versus Bradley, the court repudiated an order that required an inter-district remedy for segregation in the Detroit School District on the ground that the surrounding districts had not been found to engage in past de jure segregation. Other decisions curtailed judicial power on the basis of a premise of local control over the operation of schools. Other decisions curtailed the power of district courts to continue supervising districts over disputes about the causes of continuing segregation that I outlined a few minutes ago. And others, such as Freeman, invited partial relinquishment of supervision before unitary status of a school district had been achieved. And in these developments, the court emphasized the importance of local control and rejected the argument that the project of mandatory school desegregation might drive private housing decisions. A factor in the narrowing of the broader possibilities of Brown in society is evident in these decisions. Brown relied on the effects on Black children and the importance of education in society. It did not state a standard or a methodology and thus left open the possibility that the effects of a policy that did not mention race might, in certain contexts, violate the Equal Protection Clause due to the effect on minorities and the important interests involved. Other factors also played a role in changing the court's role in school desegregation cases. And one of those factors was a clarification of the nature of equal protection violations that the court provided in Washington versus Davis in 1978 and in McCleskey versus Kemp in 1987. In Washington versus Davis, the court officially limited equal protection violations to evidence, to circumstances in which the plaintiffs can prove that the government intended to disadvantage a racial minority. The mere disadvantage of a policy that did not mention race as a criterion did not suffice. McCleskey versus Kemp reaffirmed the intent standard in the death context of capital punishment. And there the court said that the plaintiff challenging a policy, here a policy and a system of capital punishment that sentence over 40, I'm sorry, a policy of death, I'm so sorry, I need get my water, sorry. I got it. Thank you. I don't have a place to put it. Sorry. In the McCleskey case, yes, thank you. In the McCleskey case, Blacks were 4 times as likely to be sentenced to death under the system that existed there. And in that case, the court made it clear that it's not enough to show that there is a disparity or a disadvantage as a result of a policy, that it's necessary to prove intent. And what in clarifying that it's necessary to prove that the policy, that the government adopted the policy because of its racial effect, not in spite of its racial effect. And so these two cases then narrowed the scope of equal protection to circumstances in which intentional racial classification was provable, of course, to the standards that apply in our courts by the preponderance of the evidence. So the intentional discrimination requirement created issues in school desegregation cases about the causes of resegregation and the appropriateness of remedies. Some of those cases had earlier on began to clarify a de jure de facto distinction. For example, the Keys case, that was a Denver school desegregation case. And so the question then, after the clarification of the equal protection standards, is current racial segregation the effect of prior de jure policies? And if they are not the effect of prior de jure policies, then no redress is possible. There have been other arguments about justifications for judicial intervention, societal discrimination, and other forms of discrimination, but it's clear now that any relief under the Equal Protection Clause requires that any relief under the Equal Protection Clause requires proof of intentional discrimination. And so this is a state of affairs when the higher education inclusion cases emerged. I like to call them the higher education voluntary inclusion cases, because I think affirmative action is so fraught with such angst. But the affirmative action cases between 1978 and today show the constitutional ambivalence that we have about the meaning of equality. And these cases and these policies of inclusion have been adopted at great risk. We know that we had the Bakke case in 1978, and in which the UC Davis Medical School adopted a program that permitted 16 seats to be set aside in a class of 100. 5 justices said that program was unlawful. 4 said it was legal, but they didn't agree on a common standard, nor did they agree on justifications for such a program. Justice Powell agreed that race could be taken into account, but only to pursue diversity objectives. Other justices supported societal discrimination as appropriate basis for race-conscious programs, and 4 others voted to say that the program was inconsistent with Title VI of the Civil Rights Act, which prohibits race discrimination in connection with federally funded programs. And as a result of this decision, we have 5 justices concluding that this program is unlawful, but we had 5 justices who also concluded that race could be a factor. And the court split, the circuit split, on whether diversity was an interest that could be pursued. And finally, 25 years later, the court decided the case in Grutter. In Grutter, the court held that the University of Michigan Law School could seek to achieve a critical mass of minority students in its law school class. The court did finally settle the question whether strict scrutiny would be required as the standard to review such programs. The majority also agreed that diversity was in fact a compelling interest, and Justice O'Connor found that the interest in diversity was compelling because of the importance of legal education as a pathway to the ranks of leadership and power in society. The court also decided a case involving the constitutionality of undergraduate, is that for me? The court also decided a case involving the constitutionality of undergraduate admissions at the University of Michigan, and it struck that program down because it concluded that race played too important a role in the role of the undergraduate admissions, and that violated a narrowly tailored standard. I think the passcode message is preventing me from advancing the slide. Right, okay, let me see where I am. Yes, okay. The court returned to the question of affirmative action in two cases involving the University of Texas, in Fisher versus Texas, where the Texas adopted an admissions plan that permitted the top 10% of graduates from each high school to attend the University of Texas, and also then remaining applicants were reviewed holistically in a process that considered race. In 2013, a majority of the court decided that diversity continued to be a compelling interest and that it would defer to the university on its decision to pursue diversity. It also said that any measure that used race would have to meet the standard of narrow tailoring. And it's in these cases that the court begins to clarify what is the meaning of narrow tailoring. The meaning of narrow tailoring requires proof that race is necessary to achieve diversity, or consideration of race is necessary to achieve diversity, and that there are no workable race-neutral alternatives available to achieve the desired diversity. In a 2016 case, again, the Fisher case 2, the university decided that Texas had met those requirements. Although the Kennedy majority did reaffirm Grutter, it qualified its decision with a very strong statement about its suspicion about the use of race, that race-based assignments embody stereotypes that treat individuals as the product of their race, evaluating their thoughts and effort, their very worth as citizens, according to a criteria barred to the government by history and the Constitution. That was also an occasion for Justice Scalia and Justice Thomas to say that Grutter should be overruled. Will the Supreme Court overrule Grutter versus Bollinger? On October 31st, the Supreme Court heard oral arguments on the cases Fair Admissions versus North Carolina and Students for Fair Admissions versus Harvard College. I think that we know the general facts. Both Harvard and the University of North Carolina use a holistic admissions evaluation process, which does take race into account. The Supreme Court, let me just go forward, use a process that does take race into account. In the University of North Carolina case, the district court held that the University of North Carolina had a compelling interest in enrolling a racially diverse student body, relying on Grutter versus Bollinger. The court discussed the number of applications, the number of factors considered, and also the manner in which students were evaluated. And as a result of, if you must read this case, as a result of both non-statistical and statistical evidence, the court concluded that race was not a dominant factor in selection, that race was not a defining feature in an application, and that race played a small role in perhaps 1 to 5% of the applications. In the Students for Fair Admissions versus Harvard, Harvard admitted that it used race as one of the many factors, but argued that it met the Grutter standards. In the Harvard case, after a 15-day bench trial, the district court issued a detailed opinion in favor of Harvard, and the United States Court of Appeals for the First Circuit affirmed that decision. Just the judges involved in the First Circuit. The oral arguments, of course, drew the attention of many media commentators because of some of the very interesting questions. Justice Thomas said, "I've heard the word diversity quite a few times. I don't have a clue to what it means." Other justices asked about what is the meaning of an underrepresented minority. They had numerous questions about the process, about what were the circumstances that would trigger the consideration of race. A very interesting oral argument, a chance for many of us to see Ketanji Brown Jackson in action in the North Carolina case. She recused from the Harvard case because she was on the board of overseers, I believe, of Harvard, on the corporation, I think is what it's called. And so the oral arguments were really telling because a number of the questions asked, you could argue, were maybe primarily rhetorical, setting aside positions that might be taken in advance, but there were also probing questions about how these programs actually worked. So right now, we know that Grutter is still the law. We would expect, I think that maybe the Supreme Court experts would agree, we would expect the court to actually decide this case sometime in the next few months. And one of the things that I think has been very interesting, and perhaps something that we'll hear more when the court does decide the case, is something that I'm calling the Brown chorus. So for some time now, the justices on both sides of this issue have been invoking Brown as the source of their principles. So in Parents in 2007, involving the court's decision to strike down a desegregation program involving K-12 schools in Seattle and in Kentucky, the justices said, these justices, Robert Scalia, Kennedy, Thomas, and Alito, said that the decision that they are making is faithful to Brown, and to fulfill Brown's stop using race. In Parents 2007, Justice Thomas also said that Seattle and Jefferson County, these are the schools that were trying to achieve desegregation, are like the segregationists in Brown, and that deferring to the locals is like Plessy. If you read Plessy again, you'll see that Plessy has a really important paragraph talking about deference to state officials. The Brown chorus continued on the other side with those justices who were in the dissent, making the distinction between slavery and programs of opportunity, stating that the decision breaks the promise of Brown. The Brown chorus continued in the Gratz decision in 2003 with Ginsburg and Souter, saying that the centuries of struggle for the most basic civil rights have mostly been about freedom from racial categorization than freedom from racial oppression, and to equate them is to trivialize the lives and deaths of those who suffered under racism. In Grutter, the Brown chorus continued, this time sung by the majority, discussing the importance of the diffusion of knowledge and opportunity through public institutions, and that higher education must be available to all individuals regardless of race or ethnicity. And then continuing there. And then the brief in the Fair versus Harvard case, the brief is entirely premised on Brown from the beginning to the end of the brief. It should be required reading. So what would be the effects of overruling Grutter? There have been some circumstances in which we've been able to see what difference it might make if a school could take race into account. We have California, Berkeley, with 258 black students of 7,000 in the entering class, and at the University of Michigan, also a decline. So we know that Americans want integrated schools, but too many schools are the opposite. And so when I think about what might be the consequence of overruling Grutter, I think not just about the higher education context, but what it would mean to accord constitutional legitimacy, perhaps in the way that Plessy did, to our policies in education that have the result of excluding many students. So people do want integrated schools. How would the fair case affect that quest? Our law schools are still segregated. We see that law students of color have the numbers have changed since 1978, but still those numbers are down, and especially when we look at certain groups, Native American, Native Hawaiian groups, we see very low numbers still. Our legal profession is still among the least diverse professions. Those of you who read the ABA profile on the legal profession saw that, for example, in 2012, there were 4.7% Black lawyers. In 2022, 4.5%, just as an example. Our federal judiciary is still segregated. Yes, there has been an increase in non-white people on the judiciary. In 1980, 91% of all federal judges were white. In 2022, 78%. So we see that there has been change, but that change has been quite modest, especially. Our judiciary is still segregated. Our state Supreme Courts are still segregated. And the diversity in higher education leadership is still very, very low. When we talk about what difference would it make, we have to ask ourselves how this case would fit in. My argument is that there's a very slender window of opportunity under equal protection that does not involve litigating expensive cases to prove intent on a school-by-school basis. And that would be the opportunity for schools to decide voluntarily to provide for increased opportunity. That opportunity has been cut off in the K-12 area, but it still does exist in other areas. There are larger questions about how this case fits in includes some of the recent decisions. If you read the decision in Shelby versus Holder, that demonstrates that Congress is at a low ebb in its power to legislate in the area of race, and that efforts to provide educational opportunity require millions of dollars for legal fees and doubts about the legitimacy of the students who are admitted. So as we stand on the precipice, so to speak, and await a decision, we should take note that the next generation will live in a society that's largely segregated. Richard Rothstein has written persuasively about the manner in which racial segregation operates with other conditions in society to exacerbate racial advantage. So what shall we do? Let me just go forward. So what shall we do? My thought is that we should reimagine our universities as inclusive laboratories of prosperity for all society. What might that mean? That might mean that we might need to take a much more active role in the development of the talent that we want to not only join us at our universities, but also to serve our society, as leaders. We are looking to, at Michigan State College of Law, we've made a commitment to make our own commitment to greater opportunity by enacting a diversity strategic plan, and then we will follow up on the development of that strategic plan. We're also working on pipeline programming where, and I know that you all are doing that as well, where we need to reach into our communities earlier and earlier and make sure that we are developing the cohort of students that we need for the next leaders. I always say that the football coaches do not sit in their office and wait for the cornerback to apply, or the wide receiver, or any other positions. They have an active recruitment and identification process that starts really when children are 8 or 9. You may not think that is a good thing, but they are very deliberate. They need the personnel, and they are very committed to making sure that they have it. And so part of it is to do the pipeline program. We have a responsibility to higher education to develop solutions to the effects of segregation, it's very, very important for us to do. And it is our job, and I talk about a team of interdisciplinarians like the ones that Charles Hamilton Houston and Thurgood Marshall assembled to craft an assault on Plessy and create a Brown-grounded narrative of intersectional equality. And so I say we have a call to examine the relationship between the educational policies that create or exacerbate racial disadvantage experienced by minority children and close off the flow of the talent that we would like to see in our universities and in leadership. I was arguing in 2015 that we should re-adopt Brown as a reinvigorated precedent that would ground our effort to create an equal society. Well, as I showed you in the course for Brown, everybody thinks that Brown is very important, but what I think we should do with Brown is adopt educational policies that promise to foster the full participation of our children in an exceedingly diverse, technological, and global America. Thank you. Hey, oh, do I sit? Oh, I stand, okay.
Thank you very much, Dean Greene. And now we have a few minutes for questions and answers. Are you willing and able?
of course.
I know you're able. Are you willing?
Of course.
Okay.
Of course.
So why don't I will call on people.
Yeah.
I don't know everyone's name, but I will do the pointing.
This sounds like class, right?
Exactly. And you can take the questions. And but can I ask you a question?
Yes, of course.
Okay. So in your vision for how to achieve a diverse and inclusive law school, what role do test scores and GPAs play in the process? I mean, so we can work on the pipeline, but in the meantime, we got to do something tomorrow. And that thing we do tomorrow, after the Supreme Court overturns Grutter, what are we going to do about the situation where we're supposed to not use race, but we're still clinging on to GPAs and test scores?
Well, I would say I don't think GPAs and all test scores are irrelevant. I think it depends on how we decide to use them. That we are looking, what are we looking for? We would like to know, I would say, that students are able to complete law school. We'd like to know that they are able to make a contribution to law school, but we also might want to know how they want to use the precious resource of a legal education in the future. And so it's quite possible to look at those factors and say, to whom should we afford a priceless legal education, and to make decisions. And one of the perhaps one of the challenging, but I call it an opportunity that we would have if the court overruled FAIR. I'm not advocating that they overrule FAIR, but I've explained, I didn't do my usual analysis of the vote count, but I think that there's a great possibility, unless a new approach to stare decisis emerges since Dobbs, that there will be votes to overturn. So what does that mean? What it means is we have to re-examine the entire way that we are doing business as educational institutions. If we measured, and this is probably a part of the debate, I hope it's a part of the debate over U.S. News and World Report. So if we ask ourselves, by what standard do we measure our institution? We might say we measure the quality of the institution against the diversity that it has achieved, against its inclusion of first-generation students, against its inclusion of minority students, its inclusion of the children of migrant workers. We can measure if this opportunity to transform the legal profession, I'll just speak about law, if this opportunity to transform the legal profession or the physics profession or literature, any profession, if we think that we want to change, then we have to actually look at how our own policies might be depriving us of the opportunity to nurture and develop talent that is there. So I think it's a decision to say not the standards or the devices that we use, but we ask ourselves, what's our vision? At Michigan State College of Law, I want Michigan State College of Law to be the preeminent law school serving diverse communities in Michigan and beyond. What do we need to do to achieve that? Who are the people who have to be a part of our faculty if we're going to play that role? Who are the children, young people, they're young people, who are the young people we need to educate in order to be sure that the needs of our state and the country are met? After all, I would like to make equal justice under law a reality in the lives of a broad swath of the citizens of Michigan. And so if it all has to do with what we think our duty is, we're smart enough to figure out how to either prepare prospective students for the rigors that we require, or how to support them when they are in law school or studying in any other profession. So I think that's our responsibility. Define our mission and then work back to our approach or our means.
Okay, questions from the audience, questions or comments? Please, anyone? Yeah, let's see. Okay, you're passing a mic? Okay, great. All right, passing the mic. Wonderful.
Hi. Can you hear me?
Yes, can you, is it turned on?
Can you hear me? Hello, hello?
Yeah,
Okay,
good,
great.
great.
So my name is Conti Samani, and I'm a retired United States Marshal. I had the opportunity to know Justice Higginbotham back in the mid-'80s to early '90s, and I'm glad to be here to hear your lecture. A couple of questions I have here. Number one, on your slideshow there, I noticed that a lot of the statistics showed Asian students under the category of minorities or people of color. And looking at the two cases before the Supreme Court now, North Carolina and Harvard, they're being brought primarily by Asian students, in these fair whatever it's called, I forget the name of it, fair admissions. How do we square that as far as Asians being considered minorities and in the statistics that I'm seeing up there? And the second part of my question goes to the pipeline that you had talked about at Michigan State. What does that look like, and how far back are we going to the high school level, and what type of pathways are we looking to get into your institution there?
Sure. The Harvard case is the case that presents the question whether Harvard, among other questions, whether Harvard intentionally discriminated against Asian students in the pursuit of its diversity policy. That's not, as I read the North Carolina case, that does not appear to be a salient issue in the North Carolina case, and it may be the North Carolina case involves a really big committee and many processes and checks and balances. In my reading of the North Carolina case, I don't see that issue shaping up. So as to the question, I'll just say, what is an underrepresented minority? I am interested in especially underrepresentation among domestic minorities. And then I would also say that there are different circumstances that different groups of Asian Americans have experienced that might make a particular person's experience different from another person whom we might say is Asian, but that is so overbroad a generalization because we have in our country now, we have so many different people who are now second generation, but are coming from different parts of the world, from Laos, from the Philippines, from other places where Vietnam, where their experience has been a different experience. And so an underrepresented minority, we think about that as we define what statistics demonstrate might be your expected inclusion in a particular opportunity, let's say education. As we define that, we ask the question whether your percentages in those who are able to matriculate are lower than either your presence in the society generally, or you can always talk about whether your participation is lower than what would be expected based upon your educational achievement, et cetera. So I think that it's in the Harvard case where there is a claim that Harvard engaged in intentional discrimination against Asians in the course of its program. Both of these cases, but especially North Carolina, involves a very, very detailed factual record. And it seemed that the lower court cases also were at pains to make sure. One opinion, I think, was 120 pages, another 180 pages. I think they're trying to make sure that all of the details are there for the Supreme Court to consider. So I think that there's just differences of opinion about who is underrepresented. I would be interested, of course, in a holistic admissions process. You are looking at the circumstances of the individual to determine whether, on all the facts and circumstances, that person can be successful. So for us, that question of Asian background would not be a factor. In our law school, we have had fewer Asian students, and I'm very proud that this year we have a much more robust percentage, but also of Latinx students, but also of Black students, and also Native American students. So I think that the approach is to look at the individual and to see their record may reflect privilege and advantage, and therefore it should be judged against that particular, or through that particular lens. The holistic record of a student might also reflect disadvantage, and so when you see achievement against a background of disadvantage, it's possible to say this person has what it takes in order to be successful. We need to do everything that we can to make that possible. Sure.
Okay. Thank you so much, Dean. Okay, Dean Greene, for this talk, which was really thought-provoking, and I'm going to make required viewing for my students. I wanted to ask...
Are you Kara?
Yes.
Kara, I have a picture of you with Phoebe when we went to the march in San Francisco, where we marched for equality in legal education. Do you remember that?
I do. I'll say, if I make this required viewing for my students, I won't include that.
That's really beautiful. Yeah, your mother told me that you might be here.
So I guess my question is maybe a follow-up on Professor Allen's question, both as a law school dean, but also as a dean in a state that has banned affirmative action. How are you thinking about race-neutral alternatives, and how might other places think about race neutral?
Well, for us, we are not using race as a factor in admissions. We are using a holistic admissions process. We are making sure that we have deeper information about the background of our students than we might have previously collected in order to determine not only what they have achieved against a background of privilege or against a background of disadvantage, because you my opinion. You cannot judge a person who has a background of privilege in the same way as you might judge a person who has a background of disadvantage. You're asking the question, what have they achieved? And you might see amazing achievement by a person who has disadvantage. But of course, if you are automatically preferring students from the most privileged background as the most suitable for your institution, then you are building in a circumstance where your potential numbers will be determined by the inclusive nature of the institutions from which you draw. So all of that is a part, I think, of the analysis that we would undertake. You're asking about the individual's potential, but you're not blind to their experience in society. It also goes to whether we think we would like we'll speak law schools, whether we would like our law schools to have that broad array of contacts and connections about which the court spoke of in Sweat versus Painter. I actually use Sweat versus Painter as a way of talking about how important it is for us to have these communities. I say we're not recruiting to a law school, but to a legal community. How important it is for us to have a community that is going to prepare our students to lead in the 21st century. I can say it from experience. Our students are going to practice law for 50 years. Now, if someone had told me that when I went to law school, I said, nah, I don't even know what that even looks like. But they will. And so, and our country will be even more diverse at that time, and our needs will be much more varied. And so, do we want to have a community of students who have had the opportunity to learn about each other, but also to study the particular issues that they will confront? I judge a school's commitment to diversity, equity, inclusion by who teaches, by who studies, by who teaches, by who studies, and what we teach. Because what we teach is what we are doing to prepare our students to lead through the rest of this century. And so we just have to continue to look at I don't think we need to say that we have done anything wrong. And that, of course, is the problem with the intent framework. We are looking for a person who made a single decision or an institution. Our society is more complex than that. We can examine ourselves. We can celebrate our achievements and our successes. And yet we can say, how are we performing our duty to society? How are we using the privilege that we have to be law professors or to run a law school for the benefit of society? And that's North Philly, to Radnor, or to all, just to speak of a few local places. How do we judge our success? If we're committed to diversity, equity, and inclusion, we would judge it by our people and by what we do.
Dean Linda Greene, I want to thank you on behalf of Penn Law School for this fabulous lecture. I think that it's been so insightful and helpful for you to expose us to a new way of thinking about these affirmative action cases, putting it in the general context of American constitutionalism, but also reminding us of the traditions of school desegregation and the fights we've had over it over time. It's very, very illuminating, and I so much appreciate your comment.
Thank you.
Thank you very much.
Thank you. Thank you. Thank you.
The final CLE word is history, about which we've learned a lot tonight. Thank you.
Great.
That was so great.
Oh, thank you. It was so short.
I always feel that way when I'm giving it.
I I know.
Like time flies.
It
But, you know,
does.
for the audience, there's like a natural.
Okay. Good.
And you covered a lot of ground very well, and I thought it was really great.
Yeah, well, I wanted, well, oh, my microphone. Yeah, what I really wanted to say is that there's not much left of equal protection. I shortened it. I was going to talk about Shelby and Shooty. I mean, what they did.
You gave us enough to think about. I've never really studied the Prick case, and I was